Ultimately, Malas, the reality, the real point of this doctrine is the reality to do justice has to be seen, not the formality. And Malas, your lordships should not, according to me, Malas, worry or be anxious about the fact that your lordships can never in any principle anticipate all the myriad cases or situations. Within the existing 16 principles, or any more principle your lordship may add, how is it possible that somebody will get injustice because the lordship has ample principles here?
There is some problems.
Yeah. Arbitration.
Because you are wanting an interpretation which is justice-oriented interpretation. Because this is not in the realm of public law. My fundamental problem with this is not in the realm of public law. This is purely a private remedy, purely and absolutely private remedy. Looked at in that context, section 6 has to be interpreted. Section 7 has to be interpreted. It means an agreement between the parties coupled with the subsequent sections very specifically saying that there must be a written agreement. Agreement between signatories. So the contract, the requires of the statute in arbitration law as against what we have in a civil court, where there is a remedy available to anybody, publicly provided, or compare with 226 or 32. These are public remedies as against a private remedy. So when we talk about a private remedy, it must be strictly an agreement between the parties. And to say an agreement between parties can be parties, open-ended parties. And the court will from time to time, case to case, will decide on the facts of a case, who will be the parties, who will not be the parties, depending upon public requirement and justice between the parties on a larger perspective will create a lot of problems. Because number one, every stage of section 11, you are expecting the court to do an inquiry whether justice requires a party to be brought in or not.
No, let me explain. I'm grateful.
Only consideration so far as contracts are concerned are if it is hit by public policy. Yes, of course, courts can intervene.
So I'm very grateful for the query. Let me just expand on this. This helps me to clarify. Number one, I am not at all saying that your lordship will or will not apply group doctrine on the basis of justice. Please take that as given. I'll put it, you should note it down in my submission. That's not at all. And that would be too wide, too open-ended, and it would be actually causative of injustice. What am I saying? I'm saying 2 or 3 basic points. 1. 7, for example, your lordship mentioned, which is dealt with in my later section E. There are 7 along with 3 or 4 other sections, which I've cited in my section E, are actually indicative of expansion beyond parties in the traditional sense. Not indicative of limitation, but of expansion. In the old pre-96 era, your lordship would have more easily looked at only signatories or bilateral, trilateral contracting signing parties. Take, for example, I'm giving a much larger answer, I'm just reacting to the 7 your lordship mentioned. Take, for example, B and C of 7. The idea, in fact, is to expand it immeasurably, which could never be thought of by a 1940 Act practitioner. Non-signing parties, non-parties to a contract, who are evidencing a relationship to be bound by an exchange of documents or an exchange of pleadings. I'm doing a running paraphrase.
Right.
Now,
but the problem is that 7.4b and 7.4c, actually 7.4a, 7.4b and 7.4c,
yes,
are all indicative of the fact that though the arbitration clause may not be in the parent contract, so to speak, it yet has to emerge from a course of written dealings between the parties, right? Therefore, in a document signed by the parties, an exchange of letters, an exchange
Now-
of statements of claim and defense. So all of them, A, B, and C, are instances of a written consent.
Parties.
Now, what we are trying to explore is whether the extension of the arbitration agreement can take place by a conduct of a party in, say, supporting the contract or implementing a contract, a parent,
Yes.
in relation to a subsidiary, so on and so forth. That can be really contemplate when two things. 737 arbitration agreement shall be in writing. Therefore, if you impose this now if you interpose this in certain one, it means arbitration agreement means a written agreement by the party all or certain disputes which have arisen or which may arise between them. Now, between them means whom?
Yes,
The
stated.
parties to them means the parties to the agreement. Now, parties to what? Parties to the written agreement. I mean,
Your
if you
issue
take
is
a
who
very
are
literal
parties?
construction, if you take a literal construction of this, therefore, them would mean the parties to the agreement. Which agreement? The written agreement. It can be expanded to include, say, a statement of claim and defense. But then again, it's parties to the agreement.
So real issue, who are parties? Who are parties? Who are parties is one of the core questions. Give me just two minutes.
And though none of the judgments has considered it, you may also consider it from another point of view of Section 91 of the Evidence Act.
Yes.
See, because once you have a written contract, then any oral evidence to establish the terms of the contract for adding to the terms of the contract is inadmissible under our law. 91 and 92 come under way.
Correct. Well, first of all, let me take it. A interpretation.
You're right about, on the first part, you need not really elaborate the desirability, the fact that
No,
Foro
has been
in the field for 10 years.
No.
That absolutely, as a matter of commercial wisdom.
Yes.
As a matter of fact, otherwise what will happen according to you is that you will set up only a shell company and the person behind the shell company will go scot-free. We see all that point. That's all the, but then we now have to find some textual grounding.
That's the point.
Just continuing from what Honorable Chief Justice has said, the play that we have from the previous regime, if you compare both the sections, Section 7 and the section under 1940, of course, there is definitely some amount of expansion. So the fluoro control and the subsequent progeny, as you call them, will have to be fitted within Section 7, expanded, and no further.
Of course.
No further, you can't go further. So therefore, to say justice orientation, so therefore we will see case to case and then see, it's impermissible. 1 minute, let me just complete. And in Section 7, there is a scope. Section 7 talks about 3 stages. Stage number 1, pre-agreement. Second is during the process of agreement. And third is thereafter. In these 3 stages, if something can be considered akin to a party who is a signatory, it provides, to that extent, it is permissible. The principle of fluoro control can be seen. If you see each of these sections.
A, C refers to a document. B refers to exchange of letters, etc., etc. C is a clear indication that can be post-contract also, when disputes are
Pleadings.
Because when you file a statement of claim and a defense, that is obviously after the dispute has arisen. Therefore, it is post-dispute. So an arbitration agreement can also be implied when it's in writing, arising for the fact that it is asserted by one party and denied by the other in a claim and defense.
Correct.
It is after disputes have arisen between them. So one thing is very clear, that the arbitration agreement does not always have to be a pre-dispute arbitration agreement. It can be a post-dispute arbitration agreement also.
So let me, I'm grateful.
And also just focus on later on, I mean, I just raised it, just for the, otherwise I forget it myself. Section 91 will really affect us because
Yes.
91 or 92 of the Evidence Act.
Therefore, let me.
But Dr. Singh, you have to give us a little bit of a statutory handle to conceptualize and formulate. Now,
Next. Straight away. Now, let me just sum up in the light of these questions.
I mean, very learned authorities have supported the doctrine. I mean, they know what, but
Why your lordship should
not in Indian law. So.
have any doubt about the fact that the statute does not inhibit it. That's what I am now addressing. Statute will not inhibit or prohibit or stop us in any way.
Does it by the words which are used in section 7, inhibit or stop it?
Answer is no. Tell Shibai. The real question is when come to the word parties is used right through the act, everywhere, including 7, 2H, etc. 8. Parties. Question is, was the intention ever to limit parties to signatories? If your lordships, brothers, cannot look beyond the signatories, then, brothers, look at the 3 underpinnings of the development of this law.
Yes.
The 3 underpinnings of the development of the group doctrine are already available and they provide a sufficient safeguard. And now justice is only a trigger for your lordships to go and look at that direction. Is not at all the determining factor. What are the 3 underpinnings? And that is the best answer to your lordship, in my opinion, which gives your lordships a restraining field. First, and many of them are in fluoro and some are in the later judgments. First, there must be a interconnection, a group which is clearly visible, heavily interconnected in the negotiation and implementation of the contract, performance of the contract. 90% of your lordships, brothers, fears and anxieties about other cases will go out of this test alone. Should be a very closely, this is the first test of fluoro actually, interconnected group, not in the abstract sense, for that contract, for that performance, for that refinery project, for that building. I'm not saying whether that otherwise interconnected with his parent company in USA. For that contract and performance, they have to be interconnected. Number 2 condition, there has to be a mother agreement with an arbitration clause. And your lordships has to find it to be a mother agreement, not my say. How many cases are which will not be at all?
So there
has to be a mother agreement.
So 2 conditions you say. There's
third. I'm now making it.
We just formulated one.
Yes.
First
is the group doctrine is based on a set of highly interconnected entities associated in the negotiation and performance of the contract, of that contract, I would say. Not in their own headquarters.
Associated in?
A set of interconnected entities associated in the negotiation and or performance of the contract.
Associated in making and performance of contract.
Of that particular contract.